All right, so to tell you what's going on, Janelle is handing out a mock-up of Dr. Leeser's report, okay? You saw me interview Dr. Leeser. What we did was we captured the first and last pages of his report so you understand what he reviewed and how he came to his reasoning as to substantial aggravation, all right? And we'll use his report to kind of explain and walk you through how you defend these things, what some of the pitfalls are in substantial aggravation. Also, find in your materials, the section on substantial aggravation, that is your cheat sheet. So we're toward the back of your booklets. Use that as your cheat sheet, and also use it as your cheat sheet when you leave. Because when you have substantial aggravation claims, you kind of need a roadmap, okay? Until you've become an expert on this stuff, you need a roadmap to walk you through it.
All right, so we want to make this a little interactive. First question, based on what you saw today, the witness statements and the interview with Dr. Leeser, would you certify substantial aggravation of the ankle arthritis? No, never certify substantial aggravation. Always have a doctor look at it. What kind of things do you want to do to defend a substantial aggravation case? This is an easier question than you think. Don't overthink this. What kind of things should you do? Yes, very good. Get prior records, yes. Don't certify it, and send it to your own doctor. Either get a medical file review or an IME, because what they're looking at for substantial aggravation is whether there's changes. The condition has to pre-exist, there has to be a change and a worsening, and then it's substantially aggravated. So a lay person can't really do that. You need somebody to look at it.
And Janelle raised believe it or not, we didn't say this until last week. She just raised a good issue. She said get a file review or an IME. So as employers, you always have a choice. How do you want to spend your money, right? Do you want to go on the cheap and get a file review, or do you want to come out of pocket and do an IME? Who thinks that you should get a file review? I'm tipping my hand here. You don't want to do that.
Doesn't it give you a clue as to what's going to happen? What the decision will be without having to...
Oh, the concern is if you get an actual exam, they might side with the other side. Yeah. What you're saying is if you get an exam, it might come out bad, and then you have to file it and you lose, right? With a file review, you don't necessarily have to file it. That's true.
Yeah, but you know what they're going to say without it.
There is the advantage.
Denise is talking about a strategic way of going about it. She's talking about getting a file review. That's called vetting your doctor's opinion. So if you want to vet your doctor's opinion, you can give him all the materials, have him give you a file review first to see where it's going to come out. That's a good strategy. But ultimately, to have credibility in the hearing room, you want your doctor to have laid hands on the claimant. Janelle's going to tell you a little bit later about some of the objective tests. One of the objective tests that is required to support substantial aggravation is range of motion. So you want somebody that put their hands on it, especially if the claimant's doctor is going to say range of motion is worse. Range of motion is terrible. Don't go into substantial aggravation. Need a doctor to lay hands on the claimant. But that is a smart strategy. If you want to get a set for how your doctor
Send the records to the doctor, see what they think. If it's good, then do the exam. So just a brief history of substantial aggravation helps you kind of understand what they're looking at. In 1990, the Ohio Supreme Court decided, so before substantial aggravation, that all you needed was symptomatic aggravation. So when I first started practicing, all you need, it wasn't 1990, but when I started practicing, all you needed was symptomatic aggravation. So the claimant just had to say, my ankle hurts today more than it did the day before the injury, and the ankle arthritis is in forever, and the employer is responsible for everything that happens to that ankle till the end of time. And that was kind of a harsh standard. So in 2006, the legislature tried to tighten that up a little bit with substantial aggravation, which is what we have today. Yeah, and it's like backwards, so you have to like...
I'll just hold it up. So around 2003, 2004, employers got tired of living with aggravation claims, and the bill went into process. The language went through a lot of changes. The concept behind substantial aggravation, though, was we wanted it to be substantial because that's how it was in the cases long time ago, back in the 80s, until the Supreme Court told everybody that we were all wet and you didn't need substantial, it was just aggravation. But also, we wanted some objectivity, something that you could hang your hat on, so the claimant can't just say, my back hurts worse now than it did before, because how do you test that? How do you test when someone says that to you? So the law talked about worsening, and then when they rewrote the statute and refined the language, they went back to using the word aggravation. But clearly the meaning is an aggravation is a worsening of the condition. And in 2006, when it came into effect, that was the standard that went forward. Employers got happy because, we all thought we can't lose these things. I mean, they've got to have objective evidence. And that's not necessarily true, because you get 120 people in a room like this, and people read the same paragraph, and everybody's going to read it differently. And that's true with practitioners, it's true with hearing officers, it's true with your courts. And so the commission has its own view on substantial aggravation and how you go about proving it. But when you look at the definition, it says there's got to be a substantial aggravation of a pre-existing condition by objective evidence. It's got to be documented by objective evidence. What that means is the objective evidence must show a change. That's what Dr. Leeser was talking about when he said there's got to be an interval change. There's got to be some sign that the pre-existing condition became worse. Not just that the pre-existing condition exists, which is what an X-ray by itself shows. An MRI by itself shows you got a condition, but they don't have like date stamps or born on dates. So Janelle will tell you about how the commission looks at these things.
Okay. So there's a little guidance in your handout, a couple memos from the commission about how they look at this. Good thing to remember is the commission does not require magic words for substantial aggravation. So that's kind of two things. One, when you file a motion for substantial aggravation, you don't even have to have the word substantial aggravation in the motion. Claimant can ask for ankle arthritis, and the commission can find it on direct causation or substantial aggravation. So you have to be ready for it, even if they don't ask for it, because it can come up at the hearing. They have jurisdiction to hear both, and that's the S11. The one up here just says that the commission has to specify in their order what objective findings they're relying on. So they have to say they looked at the MRI or the EMG or whatever it is. I always argue, and I continue to hammer, that you don't need, it's not just that they have an MRI. The MRI has to show it pre-existed and that it's worse, not just that it's there. And the claimants tend to want to simplify it and say, ankle arthritis, here's an MRI, substantial aggravation, allow it. And some of the hearing officers are doing that, but we have to push to try to get them to require to show the worsening. But the way they look at it, about half the time, as long as there's just a diagnostic test in there, they'll find that's good enough for objective findings, unfortunately. Mark's going to talk to you about how the court looks at it.
Well, and as I said, courts, the commission, they're made up of people, right? People have worldviews. Everybody reads words differently. Everybody sees the world a little bit differently. So what Janelle was talking about is you have to be consistent in your approach, both in the commission and in court, because it's like a recording. The more your hearing officer or the more your judge hears the recording of the message you want to give him, the more likely you're going to persuade him, okay? So the courts don't see it like the commission. The commission thinks it's a legal issue. We hope that the courts see it as a legal issue, but they don't. The way they see it, it's a battle of the experts. So if my expert says there's no substantial aggravation, and the claimant's expert says, well, there is, and this is my explanation, a judge is going to throw it up to a jury. And when you look in the materials, we have a pie chart of cases. Half the cases that have made it to the Court of Appeals got thrown out on summary judgment. Half of them go to trial. And so there's no real consistency among the courts, and there are probably I'd say about 8 of our courts of appeals have looked at this language. They don't all require that the documentation actually shows a worsening. Some of them fall into the trap that, well, if there is an objective test, that by itself is good enough as long as a doctor testifies that it got worse. And that's part of the problem. So you might think going into a hearing or coming out of a hearing, hey, we did really well. We won on substantial aggravation. We're going to win this thing again when we go to court. Not quite. You have to be prepared for the battle. You have to be prepared to have your doctor say the right kinds of things when he testifies. And also, when you're looking at your own medical evidence, you have to scrutinize your own doctor's opinion. Make sure that he's not falling into the same trap. He has to be able to demonstrate this condition did not get worse, because this objective test merely shows that a condition exists. That's all it shows. You don't need necessarily evidence before and after. The courts have said a plaintiff doesn't have to show a comparison. But if you have comparative x-rays, one before the accident, one after the accident, it makes your defense a lot easier. It makes it more convincing. It just doesn't mean that you're going to be able to walk through the court system and kick the thing out of court.
Bringing back to our case, we know that an MRI, a CT, those kind of things are objective diagnostic findings. What about changes in range of motion? Is that enough to support substantial aggravation? What does everybody think? Range of motion's worse after the injury than it was before. It is, very good, yep. It is, a lot of people think that's subjective, and a lot of times I think it's subjective, but the courts have said that's an objective test that can support substantial aggravation. What about subjective findings like it hurts in my ankle? I had arthritis before, but it didn't hurt, but now it hurts. Is that enough for substantial aggravation? It's kind of a trick. It's not enough alone, but that along with objective evidence can be enough to tip the scale. So if you have range of motion findings and more pain, that can be enough together. I handed out this report for you just to kind of show the kind of things we look for substantial aggravation. At the bottom of the first page, Dr. Leeser says there's no indication of acute trauma. You want to star that and point that out at the hearing, because that shows that there wasn't any change when it happened, such as interval uptake or edema. You heard the word interval a few times up there. And he talks about the arthritic changes, mild spurring, hypertrophic changes. Those are pre-existing. Those are the kind of things that we look at, we want to point out, not just our doctor's opinion, but we want to talk about these findings, because you can look at the testing and see which, if there's a use these things to show worsening. If there's a worsening, you see an interval change, an acute trauma. And
the other thing about the report, you think about the interview with Dr. Lee. The report we didn't talk about the injury here is a crush injury, right?
yeah.
Crush injury is a horrible accident. If you've ever had an employee suffer a crush injury of any sort, it's horrific. People buy into the idea that this injury was so bad that all sorts of conditions are going to result. Here, the crush injury was to the toes, okay? So his injury was here and in the forefoot. He's asking for substantial aggravation of the ankle. There was absolutely no evidence of an injury to the ankle. What the claimant did was complain about pain in the medial aspect of his ankle. So when you're looking at your evidence and when you're giving it to your doctor, look at it critically. Make sure your doctor understands, hey, look, this was a foot injury. This isn't an ankle injury. Is there any objective evidence that shows that there was an interval uptake in the ankle? Despite the fact that it was a horrific accident and this guy's toes were crushed and maybe were amputated, that doesn't have anything to do with his ankle. So I just want to bring that to your attention, because on these kind of claims, you have to really think critically about what you're looking at and look at the diagnostics, whether it's an MRI or an X-ray, and even the range of motion, which, like Janelle said, it's subjective and it's objective. It's a little bit of both. So what do we have, like a minute left? Psych? Oh, we've got no time left. One of the areas we were going to talk to you about was substantial aggravation of psychological conditions. We'll probably circle back to it in the panel discussion. But when you're thinking about pre-existing psych conditions, remember this. A psych condition has to arise out of the injury. That means it doesn't start until you have an injury. How can you have an aggravation of a pre-existing psych condition under this statute? Because that means that the psych condition was there before the injury. So how can it both arise out of an injury and be present before the injury? The commission thinks that makes sense. So we'll address it in the panel discussion.